has been presented to you throughout these proceedings, and I'm not going to stand up here and go over every little piece because there's 12 of you who've taken notes and you are to rely upon your collected memories. But before I go any further, I do want to do one important thing, and that is to thank each and every one of you on behalf of myself, on behalf of Ms. Day, on behalf of the citizens of Stark County, for taking the time out of your busy lives to perform this very important function. We know that it is an inconvenience in your life. We know that it appears that we don't know how minutes is never 15 minutes. But we know that you have made a great sacrifice, and for that we thank you, because you're about to go back and do the job that you were selected for. And I want you to remember that in voir dire, we talked about the fact that both sides deserve a fair and impartial jury. And when it comes to the state, a fair and impartial jury means to give equal weight to direct evidence and circumstantial evidence, not because I say it, but because the judge just told you that is the law. It means to apply the law that Judge Hartnett just gave you, not because I say it, but because that's what the judge told you you must apply. And it means to hold the state to a burden of proof beyond a reasonable doubt. Not beyond a shadow of a doubt, not beyond all doubt, not beyond every doubt, a reasonable doubt. And I like to say to juries, unless you were there, unless you saw it with your own two eyes, you're going to have doubt. But you have to distinguish between that possible and imaginary doubt and reasonable doubt, because everything in our lives is open to some possible and imaginary doubt. But you, the 12 of you, blaming Rob for his death, but also claiming I can remember everything up to that point except shooting you. Shooting Rob, who had his cell phone and his keys. The keys that were found under his shoulder when they rolled the body over, because that's where we all put our keys when we come home for the night. We lay them on the living room floor. But he had the keys because he was leaving, as he usually did. They had had a fight, and he was going to leave. He was going to go away. But before we talk about the evidence that proves her guilt beyond a reasonable doubt, let's talk about their burden in this case. They have to prove to you that she was a battered woman, that for 3 seconds she went into this dissociative state, and that she had reasonable grounds to believe that she was in imminent danger of death or great bodily harm. And the only way she could avoid that was to use this gun to pump 10 shots into Rob's body. And they have to prove that by a preponderance of the evidence. As the court just told you, that's the greater weight of the evidence. Evidence you believe outweighs in your mind the evidence opposed to it. You have to weigh the quality of that evidence. Get some things that we can all understand here. This was not a perfect relationship. It was very tumultuous. They both drank. That night, she's admitted she had 2 Jaegers, 4 shots of moonshine, and 1 beer in 3 hours. And when they drank, as you heard, Colleen liked to instigate things. She liked to start fights. And when she instigated things, she claims that Rob got physical. But there's nothing to corroborate that. But what is clear is that she had no problem battering Rob. She had no problem punching him in the face twice, once in the parking lot at Lou's, and as his mother told you, once after they got in an argument about Bentley. And she admitted, I just hauled off and punched him in the face. She had no problem kicking him in the groin. But there's no medical records, no photos, no police reports. And the one time she did call 911, she told him, no, I don't want to make a report. I just want him to go, not come home. And he did. And if she really wanted to help Rob, if she really loved him so much and wanted to help him, then why did she continue to drink with him? Why did she continue to go out to bars with him? Why didn't she just say, Rob, let's both quit drinking. I'll quit drinking and you quit drinking. And then there would be no problems. But she liked to drink. Rob liked to drink. And that created problems in their relationship. But what did you hear happened over this 8-month marriage and the 3 alleged instances of violence that gave her any reasonable grounds to believe that she was in imminent danger of death or great bodily harm? Even if you believe her one-sided, uncorroborated version of the events, he never, ever, ever hit her, let alone ever cause her any serious bodily injury. What did you hear that created an honest belief that that night something was different, that Rob was going to kill her or cause serious bodily injury? That's why corroboration of her story is so important, and there is none. There's 2 sides to every story, folks. We've all heard that saying, and somewhere in the middle lies the truth. And this now becomes a credibility issue. Because in order to find self-defense, you have to believe Colleen's version of the incidents. You have to believe that she's telling you the truth. You have to take your opinion, just like Dr. Resnick and Dr. Luba did, and base it solely on what she tells you. Not base it on an opinion like Dr. Karpowicz, who read witness statements, who did testing, who told you that she's a confident, secure woman, an Air Force security officer who wants to be a leader, not a follower. And you judge that credibility using interest and bias. Who has an interest and bias in this case? The person who pulled this trigger 10 times has an interest and a bias. Because reason, common sense, and your life's experiences tell you that he's not here to tell his side. But I submit to you that he is here to testify. Because his body and the physical evidence are his voice in this case. Because you don't just use interest and bias to judge the credibility. You use all the facts and circumstances surrounding the testimony. All of it. And all of it means the physical evidence. The evidence that is not capable of lying to you folks because it's not a human being. The only thing in this courtroom that can lie to you is another human being. Because they can sit up here on this stand and say whatever they want because one side of this story is dead. But the physical evidence can't do that because it is what it is. And it is where it is. So let's talk about their evidence a little bit. Dr. Harshberger in the video, and you have to look at these two together, the $7,000 video, because allegedly the video is based on Dr. Harshberger's opinion, at least this draft of it is. Dr. Harshberger, who openly admits that there could be many probable sequences as to how these wounds were inflicted. The man who says in court that his opinion is the most probable, but wrote in his report that it is a probable sequence. And then tried to tell you, well, there's really no difference in those. But there is a difference. And you all know that. There's a difference between saying it's a probable sequence to when you come in here in court and say it's the most probable sequence. Reason and common sense. The man who would have you believe that Rob was shot first 2 times in the mouth. These 2 wounds, according to Dr. Harshberger, were the first wounds inflicted upon Rob. Reason, common sense, and your life's experiences. Number 1 was a penetrating wound to the right side of the lip that went in an upward trajectory and penetrated his brain. Harry Campbell told you, the guy who for many, many years has worked at the coroner's office and has seen many, many bodies with head wounds. They drop right there. Rob just didn't sustain 1. He sustained 2 in milliseconds, according to this version and Dr. Harshberger's account. But yet he was miraculously able to do that little dance that you saw in the video and bend down all these ways so they can explain all these trajectories and then travel 5 or 6 feet, all the while keeping his teeth in his mouth and not dropping a spot of blood on the walls or on the floor. Reason and common sense. The other wound to his lips, first of all, the interesting thing is that it hit both the upper and lower portion of his left lip. she would have you believe he's screaming at her. That indicates that his mouth was closed. Because if your mouth's open and you're screaming, how are you going to get both lips? Top and bottom. And the trajectory of that one is downward. So this 6-foot guy's coming at this 5'6" girl, and she aims a gun at him and makes one bullet go in the right side upward, but then he's got the sense to bend down for a little bit and move his head so this one can go down. And then he continues to stand there and turn around for her so that she can fill him full of holes. That's their version. Reason and common sense. And then he travels 5-6 feet and never loses a tooth or a drop of blood. And look at where those wounds are. Side by side. Some of you I remember from where deer had guns, some of you have shot guns, and a gun recoils when you fire. If you fire that first shot, the gun recoils, and you pull that trigger right away, where's that second shot going to go? It's not going to go right here. It's going to go up here. How do you get two shots that close when you're pulling the trigger so rapidly? Or is it more reasonable? Does it reason and common sense in your life's experience tell you that those two shots were last? That those two shots came as Rob lay on his back in that dining room area, the muzzle 24 inches away from his face, as his heart pumped 1,330 milliliters of blood into his chest cavities, his stomach cavity, and his heart cavity from the other 8 wounds that had been inflicted before those two. Side by side, not a drop of blood. And he keeps his teeth in his mouth the whole way. Reason and common sense. Because remember, her version now, before it was he was standing at the end of the hallway by the carpet when I came out of the bedroom, but 2 days ago, it was when I came out of the bedroom, he was coming down the hallway at me. The truth never changes. But you heard the Colleen story as. Just like the November 13th incident, where all of a sudden she testifies that she sees him in a parking lot on the way home. She'd never said that before. And she would also have you believe that not only can she place 2 bullets side by side, in those milliseconds, even though a gun would recoil, using the or only shot one time, because again, her story changed. But in those remaining milliseconds, she can put 8 more shots into his body and never miss. And not remember a thing. And here's where the video and Dr. Harshberger's opinions conflict. Because you saw it, and you heard about the stippling, and this is the stippling. These little marks in here, that's the stippling. You heard about that. And that comes at a distance of about 24 inches. And you also heard that there were sparse gunshot powders, gunshot residues located on the front and the back of Rob's coat. Gunshot residue that was not in a definable pattern. It could not be reproduced by Matthew White, which indicates that that muzzle was more than 24 inches away from Rob when it was fired. But if it happened the way Dr. Harshberg's and the way that the video depicts that you saw, there would be definable patterns on the front of Rob's coat. Because you watch that video. The first two shots are here, and then he says the next two are here, and Rob is never more than 24 inches away. But there are no definable patterns. And you hear from Colleen that all 10 shots were fired in that hallway. But where were the shell casings? There's 6 here in the hallway, but then there's 4 up here to the right side of the body. The gun, this gun, the gun that she used to murder Rob, ejects cartridges to the right. And she does remember one thing about the shooting, and that is that she was holding the gun in this position, the standard position, the position she'd been trained as an Air Force security officer to handle high-stress situations, how to hold the gun. So if all 10 shots were fired in that hallway, all 10 casings would be right there. But they're not. And sure, they can bounce and they can roll and they can take one and put it up here and blow it off. But does your reason and common sense tell you that if it ejects to the right, that it can then come forward, not 1, not 2, not 3, not 4, not 5, but 6 feet, and then turn right and go another 1.5 feet? No. The reason and common sense should tell you that the only way for those casings to end up where they are is because that gun's up there being fired in that area, not back here in that hallway. The physical evidence can't lie. It's not a human being. That's what Colleen's doing. This Air Force security officer trained in the use of firearms, this Air Force security officer who worked at a battered women's shelter, this Air Force security officer who researched battered women's syndrome for her job, and this Air Force security officer who within 1 hour is quoting statistics while she's sitting at the police department that you will hear, have an opportunity to hear. This woman who, when she's sitting in the BAC room, and I want you to watch that video, was supposedly so distraught and so upset. There's a point in time where Detective Golke leaves the room and leaves her in there. There's two items on the desk. One is a notepad with a pen on top, and the other is a piece of paper. She's all distraught and crying. So Detective Golke leaves the room. When he leaves the room, you can see her. There's that piece of paper laying here on the desk, and there's a notepad here, and she stops crying. She gathers herself. She kind of takes a look at that notepad. There's nothing on it. And then she sees this piece of paper over here, and she kind of looks to make sure nobody's looking, and she picks it up, and she looks at it. And then she puts it back down. And then she realizes, oh, I didn't put that exactly as it was, so she shifts it back over and looks to make sure nobody saw it. Calculation. She's using her life's experiences to claim to you that she's a battered woman and that she should get away with this brutal murder that she committed. But I submit to you that the quality of that evidence is lacking. That does not create that preponderance of evidence because there's no quality to that evidence, because it depends upon Colleen, who the law says you can distrust every part of her testimony based upon the other evidence and your assessment of her credibility. I submit to you that the evidence proves beyond a reasonable doubt that Colleen McKernan is a murderer who committed a murder with a firearm specification. And what did the state have to prove? We have to prove jurisdiction. Well, we all know that this happened over in Massillon, Ohio. Massillon, Ohio is in Stark County, and that gives you folks the right to decide this case. We have to prove identification. And you all heard the 911 call, and it's very, very curious. Listen to that 911 call. Because what are the first words out of Colleen's mouth? Listen to me. I'm intoxicated. I just shot my husband. Not, oh my God, I shot my husband. Please, please, please come here. But listen to me. I'm intoxicated. She's already setting up her defense. She's already trying to find an excuse to get out of this. The other thing the state of Ohio has to prove is that she acted purposely, that she had a specific intention to cause the death of Rob McKernan. Ten separate times she pulled that trigger and pointed that gun at Rob McKernan, and she never missed. Using this deadly weapon. In a manner calculated to destroy life. That gives you folks the right to infer that she acted purposely. You heard Dr. Miller, the coroner. You heard him say that Rob died of 10 gunshot wounds, that those gunshot wounds not only caused damage to his brain, but also 1,330 milliliters of blood in his chest, heart, and stomach cavity. that he died because of a left and right hemothorax, a hemopericardium, and a hemoperitoneum. That's cause of death. And it was ruled a homicide. One person using this gun, this person using this gun to take Rob's life. The firearm specification says that she had that gun on her about her person, and we know she did. And we know that this is an operable weapon because we know all 10 shell casings were fired from this gun. And Matthew White told you it's an operable weapon. It's capable of firing a bullet. And Rob's telling you it's an operable weapon. That's what the state has to prove, ladies and gentlemen. That's what the state has proven beyond a reasonable doubt. And as you heard, as Colleen told a psychiatrist and a psychologist, she's a confident woman, free of depression and anxiety, a leader, a woman whose MMPI showed none of the traits a battered woman would exhibit. A woman who had none of the categories, none of the learned helplessness, none of the depression, none of the impaired functionality, none of the trapped feeling, none of the lowered self-esteem, none of the fear, none of the cycle of violence. None of that. And you don't have to have them all, but you got to have some. And she has none. At all. She is not a battered woman, ladies and gentlemen. She is a murderer. The evidence proves it. And I ask you to return that verdict. Thank you.
Thank you, Mr. Barr. Ms. Mills?
Thank you, Madam. May it please the court, counsel, ladies and gentlemen, it has been an honor to represent Colleen McKernan, and it has been an honor to stand in front of you for the last 10 days to tell her story. Mr. Hiltner, in his opening statement, said that you would hear evidence that on December 31st, 2014, Colleen had a choice. She could defend her life, or she could have her life taken. Mr. Hiltner also told you that had she not made that choice to defend her life, that you would likely be here for a very different trial. You would hear about Colleen's military experience for certain, and you would hear about her educational background. And you would also not hear what you heard in the state's opening statement. When the state told you that there are no signs of bruising, I can tell you that if this were on the flip side, they would be standing before you and they would...
Hold on, there's an objection. Overruled. Closing argument. Go ahead.
And they would be telling you that the completely. Not only did she try to do CPR on her husband, she immediately called 911, and as the state has said, she said that she shot her husband. She needed help. You heard that 911. Coroner's office and the firearms expert. Dr. Miller did not offer an opinion as to the shot sequence, but what he did tell us is that shots 2 through 10 were called bleed-out shots, which means that Rob would have had his full strength and capacity to grab Colleen, grab the gun, or make any other voluntary movement. He admitted that on the stand. If the state wants you to believe that there were shots other than to the face, if they want you to believe that those were not the first 2 shots, then Rob McKernan was close enough to Colleen that he could have grabbed the gun, he could have grabbed her, he could have knocked her over. He weighed 100 pounds heavier and 6 inches taller. And it also would have taken a whole lot more time. If we have voluntary movement, we have incidents, we have interaction between these two. And you would not have heard, like Secodus would not have heard, the repetitive motion that he testified to. Dr. Miller also admitted that there was more stippling on one side of the face than the other. What that tells us is that the differences are different. So, as in the animation that you saw, there could be a slight turn, and their inches is generally had to be a little bit closer than the other. Mr. Campbell tells us it's easy to unload that Glock gun, knew all about Glock guns, and he said 2 to 2.5 seconds easy to unload that gun. That he put back into Rob's mouth that evening were 2 feet behind his head. That is very important. 2 feet behind. Now, there isn't any logical explanation. If the state wants to tell you that Colleen somehow got on top of Rob and then shot him twice to the mouth, because then the teeth go back into the mouth. How is the tooth coming out of the mouth and flipping back behind the head for 2 feet? When the state tells you to use your common sense, that would be a perfect example. Practical. Mr. White, he couldn't give us any distance to the shots, but basically concluded that the first 2 shots had to be somewhere within the 24 inches. That concluded the state's case in chief, ladies and gentlemen, to which we were then able to start telling our story. And in telling our story, we first introduced a number of photographs that you will be able to look at that will just remind you of the house. I know you have the jury view, but there is approximately, 50 photographs perhaps in our books that if you need to look back, you need to look at the hallway. There's also a sketch. That is very important because the sketch that Mr. King did, he actually did measurements. And you're going to see that that hallway is only 36 inches wide. So very, very small quarters. So when the state says they don't understand why Colleen didn't miss a shot into Rob, they're so close to one another and they're in such close quarters. Dr. Harshberger gave us a probable shot sequence. He worked with the animation that you saw. And he also told you that he relied on the fact that it would have been repetitive shots in the testimony that you heard. He also agreed with Dr. Miller that if it was any other shot sequence, that would have meant that Rob would have had voluntary movement for a much longer period of time, which means he could have overpowered, he could have done some other act. He did not agree that there would be an instant drop from that first shot. Now, the state wants you to believe that Mr. Campbell says that a headshot would be fatal. But Mr. Campbell told you his patients aren't alive. He's never called to the scene for any type of wound if the person is still alive. So that's not really a fair assessment. Clearly, Rob had another facial wound to the other side of the lip, which would not have been fatal. Dr. Harshberger talked about the teeth, as we have already discussed. And Dr. Harshberger, even though the state wants you to believe that some dance was going on, which I find really quite offensive, because when you look at the animation, it tells you exactly how, within that time frame, those shots would have hit that body. And the state says there should be blood. There should be blood on the walls and the floor. This is not the movies, ladies and gentlemen. The blood isn't going to spurt out. These were hollow points that went into the body within 2.5 seconds. Rob McKernan was on the floor. Where was all the blood? The blood was inside. When you take a look at the pictures, when you're back there and you're deliberating and you look at those pictures, you're going to see a white hoodie contains a lot of blood. When he talks about all the blood loss, that blood loss was there and you're going to see it. There's no missing blood. It's on Rob McKernan. You're going to see a body bag picture and you're going to see the blood on his face. Where's the blood? You're going to see the blood. This is not a case of missing blood, ladies and gentlemen. Dr. Eisenberg was an educator. We've gone over that. He says there's no traits. He explains the threshold. He says that it's the 2 cycles. And that brought us, ladies and gentlemen, to Colleen. Colleen was in the military. She was educated. She had no prior abuse history before she met Rob McKernan. She had a savings in order to buy a house, which she saw the deed for. She wanted to move ahead and she wanted to marry the man she fell in love with. The man she fell in love with and the loving fiance turned into a nightmare of a husband. She told you she'd never had any prior problems. She never had any prior abuse with the fiance she described when she was with in the military or any of her other relationships. Oops, maybe I turned it on. What did we learn about Rob and Colleen's marriage? Well, we learned right off the bat in May, not even a month after they got married, when she had her first, when she first was called a whore and a cunt and a slut. She was told she should stay in her room, she should not interact with anyone else in the military, and that is when she hung up the phone. She had never been called those names by her now husband, previous fiance. But when she awoke the next morning, she awoke to learn that he was threatening to kill himself. Because when she wouldn't respond to him, that's what he did. I'm going to kill myself. And of course, she rushes, she talks to him, she tells him everything's going to be okay, she's going to be home in less than a week. And although the incident is upsetting, she moves forward. She just got married. She's been married less than 30 days. What happens after May? We run into June. In June, you heard the incident in which they're at the Lou's parking lot. And they're fighting in front of friends in the car. Once the friends go inside the bar, covers her mouth so she can't breathe. She is stuck with her arm behind and he says, "Shut the fuck up." He's intoxicated. She moves her fist. Did she hit him in the face? Yeah, she hits him in the face. She defends herself and she's allowed to. She gets away just long enough that he slams her down into the ground. And then all of a sudden, sticks his hand out. "I'm so sorry, I'm so sorry, I'm so sorry." She gets up. She walks into the bar. And then Rob leaves. And then Rob walks away. When the state tells you Rob always left, sure, he did leave after he physically assaulted her each and every time. But not before. From June to November, what do we have? We have a lot of name calling. We have Rob telling Colleen she shouldn't have to wear makeup to work, doesn't need to always go out with her friends. She doesn't come home instead of seeing her grandmother, her cat might not make it. That if she wants a divorce, he's going to rip up the floors, he's going to take out the water heater, he's going to make her life a living hell. He's going to stalk her. He tells her that while she's going to school at Walsh University trying to obtain her master's degree, that that's okay as long as it doesn't encroach on his time. She has to set a timer. When she has to do her homework to obtain her master's degree, she's got a timer. And when the timer goes off, that's it. You better go with Rob. Because if you ask for a little more time just to finish that spreadsheet, then the cupboards get slammed and things get pulled out and the violence starts. November 13th, 2014, you've heard that date over and over and over again because it's the date of the 911 call. Clearly they had gone out that evening. Colleen tells you that her head was slammed against the inside of the car, that she called while inside of the car. She hung up a number of times because she didn't want Rob to see her calling, and that when she was finally able to get away from the car, that she ran to Judy's. What is the first thing she said? Had she had a few drinks? She'd had a few drinks that evening. But Judy doesn't even get her in the house, and she says, Rob abuses me, right at that moment in time. Now, the state wants you to believe she didn't tell anyone. She told Judy right then, right after it happened, while it was fresh in her mind, and then she acted it out with Judy, who told you she didn't like that very much. She didn't have bruises, but she certainly didn't like that. And what did Judy do? She encouraged her to call the police, call them back, and tell them what he did to you. That's what Judy tells her. Gives her a hug, makes sure she has her phone, and sends her home. Now, this is very important, ladies and gentlemen. She goes home, she's got her phone, she plugs it in, she packs Rob a bag, she leaves him a note, she says, you're not welcome here anymore, and she locks the door. She woke up to a pillow over her face until she was unconscious. Rob broke in. Colleen testified, we were just there, you were there on a jury view, that screen door is still broken today. He broke in that house, he got on top of her that morning, and he kept that pillow over her face long enough until she was unconscious. When the state tells you that there really wasn't very many life-threatening or weren't very many serious attacks, are you kidding me? He then dragged her into a cold shower. He tried to revive her, sobbing and crying and saying, please don't die, please don't die, please don't die. And then what did he do? He left. Because what does he do? He always leaves after the abuse, but not before. November 22nd is the next day. 2 weeks later, paycheck. She's on the couch with the dogs. He wakes her up. He shakes her to the door. She tries to get out. That same door that we look at again on December 34th, she's trying to make it. She doesn't make it. She's almost to the steps. And what does he do? He rips the back part of her hoodie. He rips her back up, takes her hair. Pulling hair is not going to leave any mark, right? Pulls the hair all the way down the hallway, takes her back into the bedroom. And only when he sees his debit card does he leave. Again, he leaves after he abuses. The idea that Colleen starts these physical instances is absolutely absurd. She is asleep on at least 2 of the occasions. In December, kicked out of bed. Absolutely just physically kicked right out of bed. Do you see a pattern in these incidences? They are becoming more regular. They are more repetitive as time goes on until we get to December 31st. 2014. That party, she caught him doing drugs. She embarrassed him. He was upset. She wanted to leave. He did not want her to go to Kelly's. He said, you're not going to that whore's house. This whole idea by the state that he was going to leave, well, let her go to Kelly's then. Why did he tell her to get in the car? Why did he tell her they would just go to Mike and Abby's? She gets in the car. She thinks, okay, I'm going to go to Mike and Abby's. This will all be okay. He pulls out. He drives like a maniac. He screams, I hate you. My friends hate you. And you ruin everything. She had stopped him from doing the drugs that he tried so hard to get that night. The money exchange you see at Tucker's. The trying to avoid her at the party. He did everything because he wanted his moment, and she stopped him just like that. And he was mad, and he was embarrassed. She gets to the driveway, she composes herself, she thinks, okay, I shouldn't go in the house, I'm going to Mike and Abby's, I'm going to wipe off these tears. Instead of being able to wipe off the tears, walk to Mike and Abby's, he grabs her out of the car. Again, seems to be kind of his modus operandi, over the mouth. She can't breathe, drags her into the house, forces her back to go to the bedroom. Does she go? Absolutely. Okay. She sits down on the bed. She thinks, I got my phone. I know I got my phone. I can pull it out of my clutch, and I'm going to put in my passcode. She doesn't know there's a special button on the iPad. She's trying to put in the passcode, and Rob comes back. And what had she been told before that event? You are never to call the cops again, because he knew she called the cops in November of 2014. And so he grabs that phone and he says, I'm going to give you something to call these cops about. He leaves. She thinks she can make it to the door. She couldn't make it to the door last time because he grabbed her and he pulled her back into the bedroom. This time she takes a gun. That gun that she takes is loaded. Who was the last person to point that gun that you heard in the testimony? It was Rob to his own head. Whose side of the bed does that gun reside on? Rob's. But she grabs the gun and she thinks she can make it to the door. With the gun in the hand, he says, where do you think you're going? She's leaving. She's trying to get out. And he says, you're not fucking going anywhere. And he stands between her and the only exit out of that home. In addition to Rob always being the aggressor, we talked about how these instances are more frequent and they are more severe. And she is talking about leaving Rob on more occasions. Can you imagine not being safe in your own home while sleeping? And not because of an intruder breaking in, but because your husband is the nightmare that awakens you. The burden of self-defense is by a preponderance of the evidence. And what does that mean? If I had a ream of paper, and I split it in half, and I took one sheet of paper from this side and I put it over here on Colleen's side, the burden is met. On the floor to the time that she calls 911. Now, we know she had to look for her phone. I'm not sure where they're going with this. Certainly, Mr. Barr is going to get up and talk to you again, but if he is trying to imply that she could have done something within those 5 or 10 minutes to change the scene, she didn't knock anything over to make it look like there was a struggle. She didn't create a bruise on herself. She didn't change anything within the house that anyone indicated. They keep talking about missing shoes. But they also said that they released the house that very evening or early morning, and so anybody from the family could go in. So I'm not sure what the relevance of the shoes or the timing is, but certainly there was nothing that you heard that Colleen did to change or alter that crime scene. They'll talk to you a little bit about the booking video on certain and how she should have acted. Well, I don't know how one acts. After one has had to defend themselves and knows that their husband is dead. And they talk about how, there's a piece of paper. And you know what? When the officer left, she kind of looked at the piece of paper and then moved it to make sure it was back. She was asking if her husband was dead and no one was telling her. That booking video has instances in which she hears laughing and she thinks they're laughing at her. She doesn't know what's happening. I don't know what the relevance of her looking at the piece of paper, but I'm not sure how anyone would or is supposed to act under those circumstances. Those New Year's Eve plans that they had, they weren't Colleen's. She wanted to stay home, she wanted to have a kid party, she wanted to write down some goals and objectives for the next year. But not Rob. He wanted to go out. He planned that evening, he planned how he could locate the drugs. He continued to drink. There was nothing about that evening that was not Rob's decision. He decided to drive home in the manner that he did. He decided to not let her go to Mike and Abby's. He decided to carry her in that house, and he decided to tell her that she wasn't leaving. And he decided to move forward when she said back up. Those were Rob's decisions. Who knew about the abuse? The state seems to always say there's no corroboration. There's plenty of corroboration. There's a 911 call in November. There's a conversation with Judy, so you know that that occurred. Colleen knows, obviously. Rob knows. And Rob's mom had known of the abuse. Colleen told Rob's mom after he had shown up himself, explaining to his mom that the trouble he had with Colleen was she thought he had a drinking problem. But let's recall that when he came into Mom's house at 8:30 in the morning saying, my wife thinks I have a drinking problem, he had a Bud Light in his hand at 8:30 in the morning after a night of drinking. He said he would go to counseling. That counseling he never went to. Colleen has told you what had happened on December 31st. She has been truthful. She has been forthcoming with the police. She has been truthful with evaluators. That MMPI demonstrated that it was valid and she was honest. She has told you the times that she defended herself with the hit to the face and the kick to the groin. She's admitted that wholeheartedly. She had every right to defend herself. When Rob's mom learned within hours that that her son had been shot, she herself had a doubt whether it was murder. She was reconciling.
Sustained as to somebody else's decisions on the ultimate issue. Move on. It's for the jury to decide.
Kathy McKernan told you that she preferred that it would have only been one shot if Colleen was in fear. Let's look at what Colleen knew at approximately 11 p.m. What was going through Colleen's mind at that moment in time that they're in the hallway at 11 p.m.? She knows of prior domestic violence arrests by other women. She knows that Rob has physically abused her on at least 5 prior occasions, including suffocating her, and an abundance of psychological abuse. She knows he told her to never call the cops again and that she tried to do so. She knows he is intoxicated and believes at that point in time that he may very likely have drugs in his system. She tells Rob to back up as she wants to leave, and he moves forward. She is told, you're not fucking going anywhere. What does Rob McKernan? What could possibly be going through his head? He was embarrassed in front of his friends by Colleen. He's legally drunk. The drugs that he bought that evening with the money exchange at Tucker's was all for nothing because they're lost. He knows his wife wants to leave him. He knows he can overpower her. He knows he's gotten away with it before, and he chooses not to back up. Ladies and gentlemen, the state did not prove to you beyond a reasonable doubt that Colleen McKernan committed murder that evening. And just briefly, I want to address a few things that the state said during their closing argument. The state said that the keys were out because he was leaving. They had just gotten home. They were right next to his pocket. You'll see that in some of the pictures. The state says that he was going to leave. If he was going to leave, he would have let her go to Kelly's. He would never have grabbed her out of the car. He would have just left. She could have walked over to Mike and Abby's. They talk about Colleen punching in the face. We've discussed that many times. She has every ability to defend herself. They never hit her or serious harm. When we have testimony relative to the pillow incident, it does not make any sense. We know from Dr. Karpowicz that her MMPI test was honest. The state told you that Rob is not here. He's not here to tell his side of the story. He may not be able to testify, ladies and gentlemen, but he certainly sent a text message saying, I hate myself for ever putting my hands on you. I wish someone would beat my ass because that's definitely what the fuck I deserve. That is flat out bullshit. That is from Rob McKernan a month prior to this incident. We've discussed why there was no blood on the walls and floors and apparently skirting out. The recoil we've discussed. This is a semi-automatic. It's not going to knock her back. State said that there should be some type of GSR on the clothing. And I would ask you just to look at those photographs and that very small hallway when you take a look at that. They're trying to say that Rob McKernan should have been in the same position. As you see on that animation, that tells you the shot sequence. Ladies and gentlemen, Rob McKernan was violent when he drank excessively, and instead of stopping the drinking, instead of seeking the counseling, he was seeking a drug fix on December 31st, 2014 to bring in the new year. The promises he made were empty, and the continued violence was real. The state wants you to believe on this one singular occasion that Rob was the aggressor, but I know that your common sense will tell you otherwise. By his own admission, he abused Colleen. The state tries to insinuate that Colleen wanted this. She is a 28-year-old woman who has suffered with her unknown fate for almost 2 years, and this woman had never been previous.
Hold on, there's an objection. Overruled its closing argument. Go ahead.
And this woman had never previously been arrested. She had served her country. She
Sustained as to disregard the comment about being arrested or not. It's not relevant. Go ahead.
She has a great family, a college degree. She never had any prior abuse or mental illness. There was a decision to defend herself, a decision she will live with forever, but a decision which I know you will find was self-defense on December 31st, 2014, and justified. The shot sequence, the timing, the distance, they all tell us that that first shot was to Rob's right lip as he was moving toward her. To decide any other scenario would be disregarding the evidence, and it would not be logical. Colleen has waited a long time for today. You are all here because you were chosen and have been empowered with the ability to do justice. I know that you will not compromise, but you will hold hard to your beliefs and that you will not ignore your conscience, and your common sense will guide you. We ask that you return a not guilty verdict to the charge of murder against Colleen McKernan. Thank you for your time and your attention. Mr. Barr.
Thank you, Your Honor. If she had not defended herself, we would likely be here for a different trial. Look at this through Colleen's eyes and her glasses. And yes, look at it through her eyes and her glasses, because if she had not shot Rob 10 times, maybe, if you believe what she says, you might have had a misdemeanor assault, because that's all Rob ever did. If you believe Colleen. And I'm certainly not standing up here saying you should believe her, because the evidence doesn't support believing her. A rush to judgment? A rush to judgment? She sat on this stand and she told you she didn't want to talk to the police that night. She sat on this stand and told you the first time she told anybody about this besides her lawyers was in July when she spoke to Dr. Resnick. 7 months to get her story together. What did Detective Golke know that night? He knew he had Rob's body laying in his home with 10 bullet holes in it and a 911 call that says, my husband laid hands on me, oh wait, my husband hit me, but not a mark on her. That's what he knew that night. The night she was charged. So what's he going to charge her with? He had no idea of what Colleen's story was that night. That's not a rush to judgment. That's a decision based on the evidence you have at the time that you have to file a charge. The straw. No, they didn't collect it, but they certainly didn't try to hide it either. It's in the pictures, you'll see it. It's there. But who had access to this house immediately after the crime? Colleen. And Detective Golke, no one, not a single witness testified that they threw it out. They said, we didn't pick it up, we don't know what happened to it. So when she went back to that house, or her family went back to that house, and that straw was still there, if it was so damned important, why didn't they pick it up and take it to the police and say, hey, here's this, you forgot it?
Overruled, it's closing argument.
Officer Antonides didn't supply any relevant information? I don't even think I'm in the same courtroom. Officer Antonides told you when I got there, she was coming out the door, and then Sergeant Rogers went in, and I went in behind him. And when I got halfway up those steps, and before he got to the top, I saw casings, and I said, Sergeant, casings, be careful. And we cleared the house, and did they find any dogs, and did they find a cat? No. You think if they'd seen a dog, 2 dogs, or a cat, they'd have remembered that? Yeah, but they didn't because the dogs were in the basement. And who knows where the heck the cat was. But it wasn't in that house. And then I guess they had a party where they came in and just kicked shell casings around. Because that's what they want you to believe. But look at this picture here. State's Exhibit 3J. Oh, by the way, Colleen didn't do anything to mess up the crime scene, except she told you that she picked that dog gate back up and put it against the wall. But she didn't do anything to contaminate the crime scene. Look at this picture here. How are you going to get 10 shots fired down this way in this hallway, and then they somehow magically get transported up here, past Rob's little space here, bounce off his body, go over here. One of them even has to go over his arm and get up here. That doesn't happen unless you're shooting that gun up there. That doesn't happen because the police told you. We saw those casings before we got to the top of the stairs. And we made sure that everybody that came in there was aware of it. And we made sure that nobody disturbed them. Officer Antonides, what was your job? To stand at the head of the body until Detective Golke got there, so that if anything got disturbed, I could tell him. Did anything get disturbed? No. It's not about missing blood. It's not about missing blood. You get shot 2 times in the face and you travel this distance and fall on your back and you don't bleed, and it's not about missing blood. You want to talk about missing blood? State's Exhibit 3AA. Look at Rob's coat. Now, you did see some pictures from Matthew White that showed this coat. And this is the coat. And remember, this is the coat that has been on Rob's body while he's been wrapped in a body bag and jostled around with 8 holes in his body. But you look at his coat when the police got there, and you don't see that blood. Because it wasn't there, because it was missing. Where's the blood on his shirt from these face wounds that happened first? It's not there. Because it didn't happen that way. It could not happen that way. It is about missing blood. Because you don't see that blood like this there. And if he'd have been shot in the face, it would be there. He smothered her with a pillow. Again, you got to believe Colleen. So if you want to be like Dr. Lubin and you want to be like Dr. Resnick, then you believe Colleen's story. Because that's what they did. They just took Colleen's word for it. So if you want to take Colleen's word for it, then it's self-defense and you find her not guilty. But if you want to do the hard job, if you want to look at the physical evidence, and you want to make the right decision in this case, I can't believe Colleen. The pillow incident. She gets smothered, she wakes up in a cold shower, and what does she do? Oh, I'm in the shower, I might as well finish my shower, and then I got to go to work. Oh, no, wait, maybe I should call the police. No, I don't want to call the police. My husband just tried to kill me, and I'm not going to call the police. What are you going to do? Take a shower, go to work, and then she adds to that story and embellishes that story for the first time in here because she says, when I came home, I saw Rob in the parking lot, so I went over and talked to him, and we went home together. Never said that before. Not to Dr. Resnick, not to Dr. Karpowicz, not in the prior proceeding, but for the first time here. It wasn't cocaine. It was not cocaine. And she didn't see Rob do any. She saw him try. She drank just as much as Rob that night. Actually, she drank one more shot than him. She drank one more shot than Rob. But she wasn't drunk. There's some things that should bother you about this case. One is the timeline. Yes, I wanted to establish a timeline. What time did they leave the party? 10:55. How long did it take you to get home, Colleen? 3 minutes. Home at 10:58. What time did you hear him pull in, Mr. Sekotis? About 11. 10:58. How long, Colleen, did it take from the time you got out of the car until that body was laying on the floor? At the most, 2 minutes. She told you she sat in the bedroom for 20 seconds. She was sure of that. There was 30 seconds after she saw the body on the floor that she called 911. So we'll give her another minute to get from the car into the house. Whether she got forced in or walked in, who knows? We don't know because she couldn't tell you. That story kept changing too. 2 minutes. That puts the shooting at 11 o'clock. When Mr. Sekotis hears something that sounds like knocking. Now in hindsight, now he thinks it's a gunshot. But at that time, it was something that sounded like knocking, and he didn't count them. He didn't know how many there were. He didn't say there were 10. He didn't say there were 8. He said, I didn't count them. But he hears that shortly after he heard him get home, in his words, long enough for someone to get locked out, which isn't very long, which is consistent with her timeline, which means at the most, this shooting was all over and done with at 11:01. If you believe her version. So what's she doing for the next 9 minutes? What's she doing for the next 9 minutes? Because that 911 call doesn't come in until 11:10. But I submit to you, ladies and gentlemen, that this is what happened. Mr. Sekotis says, yeah, I heard it, thought it was knocking, I thought somebody got locked out, I went down, I looked, opened the door, no, I went back up, did some things, then I'm out lighting off fireworks. And remember, nobody else in the house heard that knocking sound. So even if you're in the living room, chances are the next 4 shots, because I submit to you, the first 6 were the 6 that defined the casings in the home. And they were probably wrapping. But they weren't to the face. They were to the side. because I want you to look at this photo. State's Exhibit 3PP. Three double P are the 3 shots to the back. 3 shots to the back. 4, 5, 6 shots in the hallway. I submit to you that gravity and this shot prove they were the first. Because what do you see here? Blood trailing from this wound, soaking the jeans. Now, blood isn't going to flow that way unless I'm standing up for a short period of time. Unless I'm standing up and I'm getting ready to leave, and someone down on this end of the hallway decides you ain't going nowhere because you pissed me off, because you tried to use some kind of drug I saw you doing tonight, and I got in your face, and battered women don't do that. Battered women don't confront their accusers, they're passive. Battered women say, honey, you do what you want, because I don't want to be battered again. That blood shows that Rob was up when those shots were inflicted. Because gravity takes it down. And unless we want to suspend the laws of gravity for this case and believe Colleen, then this picture proves those were the first shots. This picture shows that these, the 2 shots to the chest, were some of the last shots. And they were the last shots that came when Rob was laying on the floor. Because if they'd have been the first or the second and third shots, as Dr. Harshberger tells you, where's the blood? Because he was standing up. Where's the blood? Because he was standing up. This ain't about missing blood. I submit to you that it is. There's missing blood. Look at the photo of his shirt. You'll have it back there. There's blood seeping around those wounds where she compressed his chest and probably forced it out while she was doing CPR. But there's no blood running down his body from those wounds like there is in the back. What did Dr. Miller tell you about this wound? Oval-shaped bottom abrasion ring. Bullet entering this way. That's the trajectory of the bullet. What did he tell you about this wound? Abrasion ring here. Bullet entering this way. She's standing over here. Boom. This is about missing blood. And the blood that's missing on those wounds, because if he were standing up, the blood would flow down. The only way to get the trajectory in the mouth is to boom, casing. Walk around, boom, casing. One up, one down. Ladies and gentlemen, this is not a case of battered women. And the state is not saying battered women's syndrome does not exist. But we are saying that it does not exist in this case. This is a case of, oh no, what have I done? And now, how am I going to get out of it? You're going to have that booking video back there. And shortly, you're going to see portions of it. I submit to you that the physical evidence, the missing blood, the things that I've just pointed out to you, should not have happened the way Colleen says it did. And if it didn't happen the way Colleen says it did, then it's not self-defense. This is not a case of battered woman syndrome. It is a case of alcohol, anger, and firearms. That's those weak drinks that are so weak that you have to slap your hand down when you drink it. The moonshine. The 4 shots that Colleen did in 15 minutes.
I'm really drunk. I'm drunk. You should probably take alcohol for a level when I start. I am, I believe. I'm too drunk because I didn't drink. I take my blood alcohol level here, too. And I never reacted when I drink it. I told him, I said, next time he touches me, I'm gonna fucking kill him. But I'll continue to cry. When someone touches me, I'm gonna hurt them. Shut up! Shut up! Shut up!
Yes, she took this gun. That's the real Colleen McKernan. That's not the one that dressed up for you on the witness stand. That's the anger. That's the alcohol. This is the firearm. And this is the murderer. Thank you, Your Honor.
Ladies and gentlemen, I'm going to resume the instructions on page 14, halfway down. The court has instructed you on all the law necessary for your deliberations. I will now instruct you on how to conduct your deliberations and prepare the verdict forms. Punishment and sympathy. You may not discuss or consider the subject of punishment your duty is confined to deciding the guilt or innocence of the defendant. In the event that you make a finding of guilty, the duty to decide punishment is placed by law upon this court. You must not be influenced by any consideration of sympathy or prejudice. It is your duty to carefully weigh the evidence, to decide the disputed questions of fact, to apply the instructions of the law to your findings, and to render your verdict accordingly. Your duty as jurors is to arrive at a just verdict. Consider all of the evidence and make your findings with intelligence and impartiality and without bias, sympathy, or prejudice, so that the state of Ohio and the defendant will feel that their case was fairly and impartially tried. If during the course of the trial the court said or did anything that you consider an indication of the court's view of the facts, you are instructed to disregard it. Deliberations. Your initial conduct upon entering the jury room is a matter of importance. It is not wise to immediately express a determination or to insist upon a certain verdict, because if your sense of pride is aroused, you may hesitate to change your position even if you later decide you are wrong. Consult with one another, consider each other's views, and deliberate with the objective of reaching an agreement, if you can do so without disturbing your individual judgment. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if convinced that it is wrong. However, you should not surrender honest beliefs in order to be congenial or to reach a verdict solely because of the opinion of other jurors. When you go to the jury room, your first function will be to select one of your number to serve as a foreperson. The person you select to preside over your deliberations does not have any greater power, nor does that person's vote have any more importance than others. The foreperson serves the purpose of helping to conduct your deliberations in an orderly manner and to give each of you the opportunity to express your opinion. One additional duty of the foreperson is to see to it that the verdict forms and any exhibits are returned to the court after you have reached your verdict. You will have with you in the jury room 2 verdict forms for the charge against the defendant and any exhibits that have been admitted into evidence. Ladies and gentlemen, I will also tell you that you will be provided with a computer in order to play any audio or video recordings which have been admitted. Additionally, you are not to speculate as to the content of any redacted portions of the recordings or as to the reasons for any such redactions. When you have reached a verdict, you will complete the verdict form by placing the word guilty or the term not guilty in the space provided for the charge and sign the verdict in ink. If you would look in your packet to the last 2 pages, those are the verdict forms that I am now referring to. The jury verdict form, count 1, murder, reads as follows. We, the jury, being duly impaneled and sworn, do hereby find the defendant, Colleen Marie McKernan, and there's an asterisk for you to insert either the word guilty or the words not guilty of murder as charged in count 1 of the indictment. And the same was returned, signed by all 12 jurors this blank day. I apologize, verdict form should say August, wrong A month. This blank day of August 2016. Obviously, if it is not, today is the 31st day of August. If it is in the month of September, then you may cross it out and fill in the month that you are filling that in. There are lines for each of the 12 jurors to sign. And then it reads, the instructions at the bottom read, if you found the defendant guilty, please proceed to the next verdict form. If you found the defendant not guilty, please do not answer the next verdict form, but notify the bailiff that you have completed your deliberations. In the event that you are proceeding to the next verdict form, it is for a firearm specification, and it reads, we, the jury, find that the defendant, Colleen Marie McKernan, and there is an asterisk for you to insert the word did or the words did not, have a firearm on or about her person or under her control while committing the offense of murder, and that she used the firearm to facilitate the commission of the offense of murder. And the same was returned, signed by all 12 jurors this blank day. And again, I am reading August because today is August 31st, but if it is another month, you would fill in the month and the appropriate date there. And there are 12 lines for the signatures of the 12 jurors. And then at the bottom, the instructions indicate that you are to notify the bailiff that you have completed your deliberations. I'm now returning back to page 16 of your packet. Until your verdict is announced in open court, you are not to disclose to anyone else the status of your deliberations or the nature of your verdict. This is an important case. It is important to the state of Ohio and important to the defendant. You will take whatever time you feel is reasonably necessary to fully consider all the issues you are to decide. It may be difficult to remember all the instructions that I have given you. If during your deliberations you are in doubt about a portion of the instructions or have a question, such question should be discussed in the privacy of your jury room. The foreperson should put the question in writing, specifically indicating what is being requested without reflecting the status of your deliberations. Such question would then be delivered to the bailiff, who will submit it to the court. Testimony will not be repeated and transcripts of testimony will not be provided. If you leave the deliberation room, the admonitions we have been giving all along about not talking about the case, not letting anyone talk to you about the case, is more important than it ever was. So unless you are together in the jury room, you shall not discuss the case at all. And even if you are in the jury room, if one or the other shall absent himself or herself for a period of time, you would cease your deliberations and discussions at that time until everybody is present. If you do take a break from your deliberations or if you adjourn for the day, the admonition applies during such periods. Does counsel desire anything further other than the correction that I have made?
No, Your Honor.
No, Your Honor.
Thank you. I now speak to my two alternate jurors on the left end there. Jurors selected as alternates are not permitted to participate in the jury's deliberations unless one of the other jurors is unable to complete his or her service due to illness or other misfortune. I am looking at the remaining 12 jurors, and you all appear to be healthy and able to begin your deliberations. So I will tell you that your service to deliberate will not be required at this time, alternate jurors. But I would ask that you remain here once the jury does go to deliberate. I'll ask that you go down to the jury assembly room for a period of time. I'm asking that you stay in the courthouse, but you are permitted to leave and can be contacted by the bailiff if it should become necessary. So that decision is ultimately up to you. I'm asking that you stay, at least for the initial period. The alternate jurors continue to be part of the jury panel while the jury is deliberating until the jury has reached a verdict. The alternate jurors cannot discuss the case with anyone or disclose to anyone how they would have voted. After the jury has returned a verdict and the verdict is announced in open court, the alternate jurors will be contacted if they're not here and will be released from all restrictions, just as the other jurors are. It appears at this point then that the instructions are complete. The bailiff will now escort the jurors with the verdict forms. We'll get the forms and the exhibits to you after we get you out into your room. After you retire and select a foreperson, and whenever all 12, I repeat, all 12 jurors agree upon a verdict, you will sign the verdict in ink and advise the bailiff by knocking on the door. You will then be returned to the courtroom. Ladies and gentlemen, I am obviously aware that it is now just before 12:15. Should it be your desire to take a break at any point in time, whether it be for lunch or for any other reason, you are certainly permitted to do that. You just need to notify the bailiff that that is your decision as a group, what you are choosing to do as far as when you begin and how long you continue to deliberate. You are permitted, if you should desire, to bring food back into the deliberation room if you would like to do that. and continue your deliberations during any break period. As far as for meals, that is strictly up to you. You all get to control your schedule to a large degree from this point forward. You just simply need to contact the bailiff anytime you're making one of those decisions, so that we can accommodate whatever requests you are making. All right, ladies and gentlemen, with that, I would ask the bailiff to take you to begin your deliberations.